Namaskar. Today is Constitution Day, and the government is celebrating the Constitution Day in a big way. President Droupadi Murmu addressed both houses of parliament today. The government has plans to celebrate and commemorate the Constitution Day across the country with mass reading of the Constitution. We are joined by Mr. R Narayanan, the Constitution expert and somebody who has seen Parliament from very close quarters for several decades, and he has seen the dynamism of the Constitution evolving in scope through the demands of the people expressed in several other different ways. Mr. Narayanan, a warm welcome to the show.
Thank you, Mr. Manisab. I'm very greatly obliged, and it's a pleasure to speak to you, to see you, to converse with you. Thank you so much.
I would ask you to first share your brief idea about the 75 years of the Constitution and has the Constitution lived up to the aspirations of the people?
Uh, Mr. Manisab, at the outset, let me say the Constitution has contributed a lot to the country in the sense, for the first time, it is the only document which brought India into a nation. Because we had, as you know, 11 provinces plus 4 chief commissioners provinces and 552 native states, princely states. They were all scattered and they have been brought together under one umbrella that is called the Constitution of India. This is the first contribution because except Dalhousie, Aurangzeb and British, India was nation, never a nation because we have different culture, different language, different religion, different behavior, including food habits. Nothing is common. To be frank, you and I are Indians, but we discuss in English. So there cannot be a better thing than this to prove Constitution of India has contributed a lot to the development, to the unity of the nation. This is the first testimony of our Constitution. Secondly, another important point is this is the only country which has survived all upheavals, and it itself is testimony. The Constitution of India has held, remember, see, Pakistan, Bangladesh, Myanmar, Lakshadweep, this Maldives, and all countries are all in a very problematic situation, whereas our country, for the past 75 years, the Constitution has proved its mettle. That is another contribution which we can never forget. This is my view, and this has contributed a lot. And the only point which I feel is, it is like it has become a ritual. We have to make a balance sheet. What we were 1 year before at the point of 74th Constitution Day, what we are on 75th Constitution Day. Make a balance sheet. What we have achieved, what we have lost. Is there any improvement? Is there anything? See, according to me, most of the people, it has become ritual. It is an annual ceremony. Annual ceremony, like a festival, you are celebrating, you are happy, etc. But what is the contribution of the people? Whether the people in the far-flung country know about the Constitution, they are working, are they aware of their fundamental rights? Are they aware of their legal rights? Are they know how the parliament functions? These are all become a possession of elite people. The local people, illiterate people, they are not very involved at all. That is my grievance.
So basically, common man needs to be more aware about the Constitution, and the way the things are being projected seem to be ritualistic, which doesn't serve the bigger purpose. That is what Mr. Narayanan wishes to convey in his first remarks. I would like to draw your attention, Mr. Narayanan, is that while democracy indeed has been nourished by the constitution, but what are the critical aspects in the common man's life that the constitution is yet to fulfill?
It's a very good, thought-provoking question, Mr. Manisha. It's a very good question in the sense there is no constitutional morality. First point, the victim is constitutional morality, constitutionalism, and rule of law. These are all only in paper. It is not there. It is not available for a common man. There is no constitutional morality. Morality is that we implement the constitution in letter and spirit. You may be doing it in letter, but you are not doing it in spirit. Everybody knows. Everybody knows it is wrong, but nobody is prepared to rectify it. For example, I will cite without naming the any system. It is not here only during Mr. Modi's regime, or it is Manmohan Singh, or Indira Gandhi, or Devagowda. Nothing is there. It is a systemic error. Yeah, it is the first thing a governor is expected to return the bill or give assent to the bill or withhold, declare what he wants within a reasonable time. But here is some head of state who are delaying it for 2 years or 3 years. Is it constitutional morality? That is the point. Second point I want to emphasize is, yesterday or day before I saw an article in the Indian Express. There was, how many people, more than, what is known as 5 lakh people are in under trials. 5 lakh people are under trials, and at least in more than 70% people are under trial. One second, I will give the exact figure. More than 5, many people, that is, under trials are more. And if you analyze, most of the people are Dalit. Most of the people are Muslims. Most of the people are Sikh. Majority of the people are other communities. And most wonderfully, 68% of the people are illiterates. Another bad thing. So these people are under trials. Remember, they have not been found guilty. What is the jurisprudence principle? Every person is innocent until unless otherwise is proved. What we are doing for this? You try him and punish him. That is a different issue. Without any trial, these people are in the jail. Means, is it not a violation of liberty? This is number one. Number two, that I am not talking about targeting any particular institution. I am putting only the fact. If the difference may be, but the fact is a fact. Nobody can disagree. 5 crore cases are pending in the court. 5 crore cases. 88,000 cases are pending in Supreme Court alone. Supreme Court alone. When we are talking about accountability, where is the accountability? Where is the accountability for the judiciary? What is the reason? Lack of judges? Or there is no adequate number of judges? Make it. Or there is laws are hurriedly passed. As a result, there is interpretation of law. Different parties interpret the law in different way, different method, depending upon the convenience. So this is another. These two things are very, very important. In fact, I remember Honorable President of India mentioned about the under trials, the overcrowding of jail. So this is another point which I want to emphasize.
Indeed. In fact, Mr. Narayanan has given different religious backgrounds of the under trials, but we can also club them together, saying that they are economically underprivileged class who don't have the means to access judicial remedy, while we see headlines in the newspapers about well-off people, influential people getting bails in very short span of time, and even those who are under trials getting on released on parole most often. So I think we can consider a classification that economically impoverished people happen to be very negatively impacted because of the judicial delay. While we are discussing, Mr. Narayanan, we came across a news today that in Mexico, judges for the first time ever in any parts of the world would be directly elected by the people. So that is a very novel kind of an experiment that Mexico is holding, and maybe what you have raised the concern could find solutions if people directly get involved in some or other ways. But I would like to ask you, Mr. Narayanan, that we indeed have several fundamental rights, but Article 21, right to life, but do we really have that kind of a right when we are subjected to live in gas chamber in Delhi NCR, when the means of living our rightful or healthy life is deprived from us?
No, I agree. See, right to life and liberty, right to live with dignity, in fact, the right to live with the right to die with dignity, all these things have been included under Article 21 of the Constitution. And not only that, Article 21 nowadays it is not only due the procedure established by law, it is due process of law. That in fact the Supreme Court has expanded the scope of Article 21. It does not include, it does not say merely by a procedure no person shall be deprived of his life or personal liberty except by a procedure established by law. Whereas now it is due process of law. That means you can question the wisdom of the law also. You cannot, previously you cannot question the wisdom of the law. Legislature is placed over and above the executive. Whereas now the Supreme Court is interpreted in such a way that procedure established law includes what is known as due process of law also. After Mrs. Manaka Gandhi's case, it has been decided. So as far as the pollution is concerned, again, all things here in a problem is arises because of the mindset, because of the what is known as blame game. State government putting the blame on the central government, one state government putting the blame on the state government. We cannot decide the issue for years together. That is the saddest part. You want to settle LAC, LOC during the short period. You want to settle Ukraine and Russia. You want to settle what is other Hamas and other scenarios. Whereas you don't want to settle it by sitting across the table, give and take, and taking a consensus situation, consensus position with all the people. Why you cannot do it? Why Haryana and Delhi cannot do it? Why Uttar Pradesh and Madhya Pradesh cannot do it? See, this is the problem. We have to understand. See, Ambedkar clearly said, if you are dealing with the constitution in the better way, even you can convert a bad constitution into a good constitution. Absolutely no doubt. If the constitution, howsoever the constitution is good, the people who are handling the constitution is bad, the constitution will turn out to be bad. However, the people are bad. If however the people are good, the constitution will become good. So it is in the how the people handle the situation that is the important. That is my view.
So, what is very important is that the people who constitute the executive, the legislature, and the judiciary, they have to ensure that the constitution is implemented in letter and spirit.
Letter in spirit.
Yes,
That is the
in its
first.
letter, in its spirit. There should be
Yes.
no dilution of those things, and
Yes.
there should be a culture of following the strict norms of the constitution as laid by the
Uh,
makers of the great
yes.
statute book.
Yes.
Going
Constitution
forward,
already.
constitutional morality. Rather, we should, in place of doing a ritual of each year on November 26th, we should establish the constitutional morality, and we should also judge the constituents of the legislature, the executive, and the judiciary. How do they perform on the constitutional morality? Mr. Narayanan, I would like to draw your attention to the fact that we have a written constitution. In some parts of the world, convention is as equally important as the written constitution. How do we figure on that?
See, there is no constitution called a written constitution or unwritten constitution. We have unwritten constitution. For example, UK is unwritten constitution. New Zealand is Israel is unwritten constitution. But that does not mean there are no constitution at all, because they have a number of law, Reform Act, Magna Carta of Civil Liberties, Settlement Act. There are so many acts have been made to replace the constitution. Written constitution means a constitution evolved by a body, by a group of people. Even in Indian constitution, we have a number of conventions. For instance, PA Public Accounts Committee chairman should be from a leader of opposition, where it is written. And normally, if vice president is, what is called the south president should be from the north, where it is given. Deputy chairman plan this Rajya Sabha should go to the opposition. Deputy speaker should go to the opposition. And when the prime minister speaks when there should be no interruption. When a maiden speech of the member of parliament should not be interrupted, and the speaker's orders are final, there cannot be any misinterpretation. And parliament is what is known as supreme. These are all convention only, where it is given. Nowhere said the parliament is supreme, or even judicial review has not been given in any of the provisions of the constitution. It is only interpretation of Article 13. So, without convention, nothing is possible. There are conventions. There are conventions. Suppose if a president is the majority community, vice president will be minority community. It is a convention to encourage people to give equal status and equal opportunity to give the impression. Appearance is more important than the reality. The appearance, an onlooker should see how you are conduct the country. That is important. And another problem here is, you were mentioning three wings of the state: executive, legislature, and what is known as the judiciary. These are all on paper. In fact, executive and executive and the legislature, there is no blurring, completely amalgamated. Where is the parliament independent? You tell me only one act which has not been cleared, I mean, which have been objected to by the cabinet. I mean, cabinet clears it. Whether parliament negative it, it's not possible. So here, the executive is part of the legislature, parliamentary form. There is no strict separation of powers. Separation of powers are there only in USA, not in India. India, separation of powers only limited extent by the judiciary and legislature, and legislature plus executive, on the other side judiciary. This is a strict separation of powers. You can, because executive is always at the mercy of the parliament. This is it is, I mean, yes, somewhat, parliamentary form of government. This is parliamentary form of government is suitable for the, according to me, I may be wrong, suitable for the elite countries. That is very literate country, UK. There it is possible. Here the layman does not know who you are electing the people. All the ministers are, I mean, most of the ministers do not know what is a bill, what is the bill. To due regards, I don't say, because they are people's representatives. And our constitution, in such a situation, we now that if you see the act functions of the government, they are mainly concentrating enforcement of law and order. There is an or what is known as a people's requirement, giving freebies. Actual development work, actually it is now, after 1991, it is a privatization. So even the fundamental rights have to be modified in such a way to cater to the needs of the, our rights should be not only against the state, our rights should be against the individuals also, against the private sector also. We do not care about it. That is another problem in the, the only area where the something can be done is judiciary. They should wake up and they should do it.
Mr. Narayanan, I remember you had written a column for the Raisina Hills in which you had argued that the Constitution is federal only in letter, not in the spirit. Can you please explain what did you mean by that?
See, Constitution is only federal in structure, unitary in spirit. There is no territorial integrity. There is no territorial integrity at all. That means, any state can be created or abolished or modified or amalgamated, bifurcated, name can be changed, boundary can be changed, territory can be changed without the consent of the state. Very simple. Without the consent of the state, any state can be created. If Mr. Modi wants, and maybe better also, in fact, suppose if he sees these two states are fighting, we will amalgamate. We will join Tamil Nadu and Kerala and other state. Perfectly, it can be done. No need for any agreement. You just refer a bill to the president. President will recommend introduction, and it will be introduced, passed by both the houses of parliament, and it will be passed by simple majority. It will not amount to what is known as a constitutional amendment under Article 368. The only formality the president should refer this, he should refer the bill to the concerned state legislature for their views, quote, for their views. And even if they give opposing views, it is not binding on the president. Most importantly, the satisfaction of the president is satisfaction of the president is satisfaction of the council of ministers. Very simple. Even Rajya Sabha has no role. Rajya Sabha is one of the part of the parliament. Rajya Sabha, even though it is so-called representative of the states, it has no role in changing the name of the state, changing the territory of the state, creation of the state. So absolutely, there is no territorial integrity. That is why constitutional experts say it is an indestructible union with destructible states. That is a indestructible union cannot be destroyed, but states can be destroyed in 5 minutes. And take J&K.
Yes.
Again, take J&K. Can you cite a state which is downgraded into UT without legislature and with the legislature? And when it is challenged in the Supreme Court in its wisdom, Supreme Court said they will upgrade it by particular date. See, that means tomorrow, if Modi will not do it, RSS will not allow it, okay. But tomorrow, somebody else like me, I come, I say all these things are problem. Why make only 4 states? Where is the territorial integrity? Nothing. And Rajya Sabha, you say representative body. What is Rajya Sabha? How many? What is the 12 nominated members? Tell me, is there any constitution which has nomination in Rajya Sabha? It is representative of states. You have 12 people are nominated. And is there any criteria? You say 5 criteria you have given in the constitution. But how many people? You tell me how many people? I mean, caste one. You take caste census. You take Bharat Ratna, these Rajya Sabha members. How many people are nominated? How many are Dalits? How many are other communities? Nothing, no criteria. And wait to the equation. UP has got 30 members, whereas Sikkim has got only 1. There is equality. You say that is the only area of Rajya Sabha membership. That is also not fully representative. So it is only name. It is federal in structure, etc. And you take another most important glaring. A bill is given. A bill is passed by both the houses of legislature if there is a council. Otherwise, it is passed. It is presented to this governor. What he should do? He should give consent if he wants. And there are certain. He has got full discretion. He has full discretion is there for the governor. He can reserve the bill for consideration of the president. Under Article, 200, he can reserve the bill. Where it is violation of directive principles, where it is a violation of union law, where it is in concurrent list, where it is derogatory to the High Court, where it is against public interest, he has the discretion. Okay, you reserve. Immediately you should take action. Send it to the president. Okay, if you send it after 1 year, 1.5 years, and then president keeps it. President does not mean it is the council of ministers. President under Article 74 is only a nominal head. It is who delays council. They don't take this decision. In fact, in the position is suppose even if the bill is referred to the state legislature for reconsideration by President of India, President and the legislature passes the bill again, President is not bound to give the assent. Remember. So these are all gray areas in the constitution, in the center-state relations. And finance commission recommendation also, the same thing. There is no criteria. And another thing is our states are also one way, they are all party-based politics. All party-based politics. If the party in power, the center in power, like that. It's a much said, less said the better. That is the situation. Technically, I don't think there is. And you take Schedule 7, what is called 9, Schedule 7, division of powers. How many subjects are there? 97 subjects for union, and 61 for state, 52 for the concurrent list, and the union subjects are more than the state list. A union has the advantage 97 plus 52, whereas state has got only 67. Where is the powers? And in addition, under Article 249 of the Constitution, Parliament can make a law on the state subject. And when the 248 residuary subjects belong to them, when two or more state legislatures, they can make a law. And union territories, totally they are free. To implement any treaty or agreement, they can make. And you tell me, without bringing any constitutional amendment, they can bring a state under president rule. Article 356. There is no constitutional amendment. You bring this under the president rule. Article 350. That too, where if the President of India is satisfied on the basis of the report or otherwise, if the state administration is not run in accordance with the provisions of the Constitution, the President will declare president rule or constitutional emergency or state emergency. That's all. What is the report? You cannot see. It is cabinet advice. It is not susceptible to anyone, except in Sarbame case, Supreme Court said, no, we have to see. So these are all the lacuna. These are all we are not, because you have to see the background of the framing of the Constitution. Why we are not saying, at that time when the Constitution was framed, there was partition, and India was never in. As I said, it was never a nation. And if that situation was allowed, India would have been split. But for Sardar Patel and VP Menon, the India would have gone into 552 states. Definitely. That is why the Constitution has made the reorganization states so flexible. But there is a need that we should give more powers to the state governments, and autonomy should be there for the state also. At the same time, responsible government should be there, accountable government should be there. That we have to ensure. Maybe Rajmanar committee, or maybe other committee reports, or plenty of committee reports are there that we have to take into.
We have a lot of committee reports, and India is also popularly known as very efficient in drafting documents. So in that way, we have a very good constitution which has lived up to the expectations of the people. But Mr. Narayanan, I would like you to comment that the members of parliament are basically known as lawmakers. They make laws which become part of the constitution, subject to the judicial review. But the anti-defection law binds them in whip. So whatever the government wishes, they get carried in parliament. So do we really have lawmakers in the true sense who will really protect the constitution and take care of its true interests?
Mr. Manisha, I will say again, it is a farce. I don't think. Because in a parliamentary democracy, as I told you, what executive wants, it is done by the parliament. There is no parliamentary independence. Parliament strictly has no independence. There is no, you know, the powers of the parliament is not there. Technically speaking, first limitation is constitution itself. Constitution says don't do 99, or you have powers only on 97 subjects. You cannot do rest of the subjects. Secondly, another thing it says that judicial review, Article 13, the state shall not make any law which it takes ever abridges any other rights conferred in Part 3 of the Constitution. You cannot do. If you do, it is judicial constitutionality law will be questioned. Article, that is judicial review, Article 13 and 32. Thirdly, you have the basic structure. Where is in which constitutional provision there is a basic structure? Tell me. Nowhere. No provision of the constitution mentions about the basic structure. But we have basic structure. You cannot touch. National Judicial Appointment Commission Act was nullified by the Supreme Court, invalidated by the Supreme Court. And in addition, Article 142, that itself Supreme Court can make any law. In fact, law, triple talaq, for example, they can make law for doing complete justice. They are taking away the powers of the parliament. So where is powers of the parliament? Number one. Number two, members of parliament, we require constitutional literacy. With due regard, instead of going and telling, celebrating all these things, you ask indirectly, make a survey. Make a survey. How many members of parliament know about the fundamental right? What is difference between fundamental right and legal right? What is how a bill is passed? Do you know a bill to be passed? It requires only, say, 31 members. Only 31 members. We may say if 31 members are supported, we will say the bill has been passed unanimously for public consumption. Because what is the rule? What is the provision? Subject to quorum, number of members present divided by 2 plus 1. What is quorum? 10%. 543 quorum 55. Let us say 55. 55, let us say 60 people are there in Lok Sabha. Divided by 2, 30 plus 1, 31. If a bill has been passed by 31 members, it is unanimously passed. Unanimously. Is it not, mockery? Is it not mockery? You pass a bill and it is universal application. Remember, all over India and central, a law passed by the parliament, not only applicable to entire country, it is applicable governing the subjects of outside also, Indians living abroad and their property. But you are making a law with 31 members. And is there any control? Is there any accountability? Except, what is quorum? And even if quorum is not there, quorum speaker is not a headmaster, so he cannot count all the people unless opposition objects. You see the procedure, and you are telecasting the procedure. You see on a Friday afternoon, private member bill, how many members of parliament are present?
True.
How many? Nothing. Nobody. How many? See, with the due regard, I'm not saying they have got more important work. I agree. But in a parliamentary democracy, there cannot be a more important organ than parliament. You are meant for that. And how many members participate in the discussion? And how many people know? How many people take an independent decision? It's all party right. I have, with due humility, with all my humility at my command, I have worked with the Public Accounts Committee for 5 years under Mr. Mallikarjun Kharge as well as Professor Thomas. Many sensitive issues were carried. Many sensitive issues were all discussion on party lines. They cannot deviate from the party stand. All standing committee. Today I saw an article in Indian Express about bills are not referred to the parliament, committees. Many bills are discussed. What is the fun? Even if it is referred in the JPC formal, what is JPC? It is a party line. The ruling party will have more members and the opposition will have less members. There is only What is? Are they going to take a stand against the party? No. Even in the party, I want a discussion on 193. Somebody says, I want 184. Okay, you make the discussion. Finally, what is going to? It is a discussion club. I don't think you may say it is a discussion. What is the outcome? It is only public consumption. It is only you show in the parliamentary record, I have opposed this. So the real matter is that they should be, people should participate. Members of parliament, first requirement is not that, to gimmickry before the public giving freebie or other thing. They should be understand. They should understand what is constitution, what is bill, what is the subject matter. Why so many amendments are there? Very fact that you amend a bill, that means the original bill is not correct. That is the implication. That is so. I don't.
So,
They
so constitutional literacy is the basic necessity for the people. In place of celebrating like a ritual, the people should rather focus on gaining more literacy about the constitution,
yes,
and it is incumbent among all the stakeholders to uphold the constitutional morality, and in only in that case we would be able to live up to the aspirations of the people and also the expectations of the makers of the constitution. Mr. Narayanan is diving deep from his deep reservoirs of knowledge gained from his practical experiences. We could have carried on for longer time, but we'll abide by the time limitations, and we'll ask Mr. Narayanan to share his views and insight in another episode in near future on some other aspects and the subject. Thank you so much, Mr. Narayanan, for talking
thank
to
you.
us.
Thank you, Ms. Manisha. Thank you. Thank you.